What are the key requirements in the Digital Personal Data Protection Bill of India? Let's find out in this video. Hello and welcome. My name is Punit Bhatia and I'm going to be talking about key requirements in Digital Personal Data Protection Bill of 2023. Now, by the way, if you haven't watched the definition of key terms, another video which I did a few weeks ago, then please do so because I will be using some of the key definitions that I discussed there. So it can be helpful for you. Now, what are the key requirements? And I'm going to break it down into 12 simple requirements. So let's start with requirement 1. Requirement 1 is grounds for processing of personal data. Yes, personal data must be processed for legitimate purposes, and this law defines consent as one of the key grounds for processing personal data. Yes, compared to EU GDPR, which has 6 different grounds for processing of personal data, this one relies on consent heavily. Consent meaning asking the individual to explicitly agree on processing of his personal data, and in this case, as it relies on consent, in my view, the unique thing is consent and contractual agreement as in the EU are being used interchangeably here. So there's no reference of contract, it is consent. So for me, consent is the contract and it's not the consent that we are used to talking about in EU GDPR. Then in addition to consent, it also permits usage of personal data based on legitimate uses like compliance with law. One of the key aspects here is that it mandates a notice describing personal data that are collected and explaining the purpose of processing. One of the things I like about this law is that it gives you a lot of examples explaining different requirements and how they can be applied. For example, when you talk about legitimate basis for processing or grounds for processing, in fact, it calls grounds for processing personal data. Let's say you are an individual. You open an account with a bank using maybe their mobile app or a website. So you go to an ABC bank. Now you complete the know your customer requirements under the law. And as you open the account, you opt for processing of personal data of this ABC bank in a live video-based customer identification process or maybe in-person customer identification process. Here, as per the law, the ABC bank is asked to accompany or precede the request for processing of personal data with a notice to you describing the personal data and the purpose of processing. So it is for me similar to what we call the privacy notice in the EU GDPR, or at the time of consent when you say this is what we will do with your data. That's very similar. So consent and other legitimate bases like compliance with the law. So the first requirement is grounds for processing of personal data. And the second one is contracts with data processors. So while you collect personal data as a data fiduciary, you may want to work with a third party for certain services and they may get access to the personal data that you've collected from the data principal. You need to make a valid contract stipulating their responsibilities and obligations when they are processing personal data on your behalf and in line with this law, that is the Digital Personal Data Protection Bill. In my opinion, this is very similar to what we have in EU GDPR, that if you hire a processor, then you make a contract. The third one is security of personal data. Again, very similar to EU GDPR, it talks about company collecting and processing personal data, that is the data fiduciary, must apply appropriate technical and organizational measures. It does not go very deep into it, it leaves it there, but it's very, very similar to EU GDPR. So the fourth requirement then is the data breach notifications. Again, similar to EU GDPR, but no 72-hour rule. So that's a relief for some companies. So data fiduciaries shall give the board, that is the Data Protection Authority, and each affected data principal intimation of a breach in form and manner that may be prescribed. That means more information, more guidance would come on how these notifications are to be provided. Maybe then they also add some time frame, but for now, no time frame. Now the fifth requirement is personal data retention. Yes, this is always complicated. That is a data fiduciary shall, unless retention is necessary for compliance with law for the time being in force, erase personal data upon principal withdrawing his or her consent, or even as a general obligations of data fiduciary. So in both cases, the person has withdrawn consent, you delete data, the person exercises right to erasure, or even as a general obligation. And it says as soon as it is reasonable to assume that the specified purpose is no longer being served. So whichever is earlier, the individual asking or the purpose getting over. And not only that, it is the obligation of the data fiduciary to notify the data processor of such an action. Now let's understand this with an example, because retention, as we know, can be complicated. So let's say as an individual, you register yourself at an online portal or a platform, say an ABC e-commerce provider. You give your consent to this ABC e-commerce provider for processing of your personal data, let's say to sell cars. You make an account, you register your car, you do everything, and then the online marketplace helps you conclude this sale of your car. The deed is done and you choose to close your account. This means ABC company shall have no longer the need to retain your personal data and should delete it. However, on the contrary, if this same example was in context of a bank, the bank needs to retain personal data for compliance with legal law, and hence they would be allowed to keep the data. So retention, equally complex as in EU GDPR. Now the sixth requirement is contact for concerns and complaints. Now what does it mean? A data fiduciary shall publish the business contact of a DPO if it's assigned or if it's applicable, or a person who's able to answer on behalf of data fiduciary. That is, any question the data principal may have, they would need a contact into the organization so that their concerns are answered. And it also applies to any grievances that may have. That means data fiduciary, that is companies collecting and processing personal data, would need to establish a grievance office or a digital office so that grievances of data principals are addressed. So normal contact for questions as well as for grievances, with difference being DPO may or may not be assigned. As we discussed in the other video, the DPO is mandated only for significant data fiduciaries. Now, the seventh requirement in the Digital Personal Data Protection Bill of India is interesting. It's not called interesting, by the way, it's called rights and duties. So, rights and duties. You remember in EU GDPR and in most privacy laws, we talk about rights. But here there is also a balance by saying duties. So, let's first understand the rights. Rights are more or less similar to what we have in EU GDPR, right to access information about personal data, that is, have a copy of, have information about what personal data is being collected, right for correction and erasure of personal data. That means if it's incorrect, you get it fixed and also ask for erasure. The right for grievance redressal, that is, in case the individual has a grievance about processing of personal data, they can ask and they can get it answered. Here again, they do mention the consent manager. If you remember, I talked about the consent manager in the key terms or key definitions. So consent manager is the intermediary or the representative of the data fiduciary or somebody who's acting on their behalf that can also address the grievance. And another one is the right to nominate in event of death or incapacity. That's an interesting one as well, which is not there in the EU GDPR. Then, as I said, they talk a lot about duties, which in a way it's a good thing, because based on culture you also need to emphasize this aspect. So a data principal, that is the individual whose personal data is being processed, would have to comply with the provisions of all applicable laws for the time being in force. So they don't limit it to the Digital Personal Data Protection Act, but they say all laws. And also the data principal needs to ensure that it is not impersonating as another person while providing data, which is, I think, fair. And then another thing is they make it explicit that it is your duty not to suppress any information when you are providing personal data, like documents, identifiers, proof of identity, etc. Another thing is not to register a false grievance or frivolous grievance. That is, I think, again, fair. And again, when we talk about grievance or complaint in false nature, that is towards the data fiduciary or the board. And finally, it is also about furnishing information that is verifiable. So these are some of the duties they have assigned. And as I said, they balance the rights with duties because they want to emphasize that it is also the responsibility of data principal to provide the right information and not falsify the information. Now, with that, we come to the eighth key requirement, that is the significant data fiduciary. Yes, we talked about it in the key terms that central government may notify a data fiduciary or any data fiduciary or a class of data fiduciaries as significant data fiduciary. What does it mean? That is, the central government would conduct an assessment and basis that assessment, which will have many factors like, does it involve the processing of personal data of children? What is the volume and sensitivity of processing? Is it creating a risk to rights of individuals, what is the potential impact on the sovereignty and integrity of India, maybe risk to electoral democracy, security of the state or public order. In all those functions, the central government may classify a data fiduciary or a class of data fiduciaries as significant data fiduciary. And if that happens, you are subject to some additional requirements like appointment of a data protection officer, like appointment of a data auditor to carry out data audit. Now that's also new, that's not there in the GDPR. Of course, it talks about audits, but here it's dedicatedly saying that you need to appoint an independent data auditor to carry out data audit. I think this is more geared towards the big tech, but we will see how it comes up. And then also they expect significant data fiduciary to conduct periodic data protection impact assessments. Yes, a DPI, which is a requirement for all data controllers and all processing that can create a risk. Here, it's being limited towards significant data fiduciaries. I think it's an attempt to limit the impact on general companies in India and only limit it towards companies that process personal data in a significant way. And I see this being towards the big tech. So that was the 8th one, and now the 9th one is processing of personal data outside India. This law applies to processing of personal data in India and of Indian citizens. Now here the interesting aspect is that central government may by notification restrict the transfer of personal data by a data fiduciary for processing to a country or territory outside India. Now that's interesting. You're allowed to do data transfers, the law would apply, but central government may place a restriction in certain countries. We will see how it develops. So that is the 9th one, and the 10th one is that this law has a lot of exemptions. Personal data of data principals not within the territory of India, that is people who are not in India, if their data is being processed and it is subject to any contract, then this law would not apply, which means that essentially they are saying for all the outsourcing contracts wherein the EU, US or data of foreign individuals is coming in, that will remain governed by a contract as I understand. Of course, we'll get to know more about it. It's kind of an outsourcing exemption. While this makes me wonder how would it impact India getting adequacy from EU or UK. But for now, there's an outsourcing exemption. That is, all those personal data processing would remain under the contract and not under the preview of this law. This law has a lot of exemptions wherein this law would not apply. The other one is the state or the central government has a lot of powers, a lot of options wherein they are exempt from the Digital Personal Data Protection Act. Not only this, they allow for exemptions in case of arrangement for mergers, compromises, amalgamation of companies, or reconstruction by way of a demerger. There is also an exemption in case the processing is for the purpose of ascertaining financial information or assets or liabilities of any person who has defaulted a payment. So essentially insolvency and bankruptcy, that's what they are aiming to do. And where it goes a little bit over the board is it says the central government may, having regard to the volume and nature of personal data processing, notifies certain data fiduciaries or even a class of data fiduciaries, including startups, as exempt. Now, this is a little bit ununderstandable for me, but we will see how it shapes up. Now, the 11th requirement is the board, that is the Data Protection Board of India. So just like the supervisory authority in Europe or the data protection authorities in Europe, a board shall be constituted with a chairperson and members that will be appointed by central government. They will hold a term for 2 years, which can be extended. That means they are eligible for reappointment, and they will look into the aspect of data breaches, complaints, making sure this law is complied with, issuing fines, guidances, and everything like any other data protection authority in the EU does. Now, here there's an interesting twist or an aspect. While the Data Protection Board can issue fines, penalties, and everything, companies, that is data fiduciaries, would have the opportunity to appeal to a tribunal. Now, I'm not understanding why this was needed, because if you have a board and if you want to make an appeal, you can always go to the courts and there is a judiciary system already in place. But here they are setting up a tribunal, so which means an additional step before somebody goes into the judicial system. That's fine. It provides companies an opportunity, and maybe on a good part, this would result in the appeals getting fast tracked, because this tribunal hopefully would have the role of only processing the appeals, and then it would go faster for companies. Now, the 12th requirement is about penalties. So if you do not comply with the law, or if you're found that you're not complying with the law, based on the nature, gravity, duration of breach, or maybe type and nature of personal data being processed, and also the repetitiveness of your breach, and whether you have made a gain or a loss, and what actions did you take as proactively or even after detecting the breach, you may be issued a fine. That monetary penalty can be imposed in proportion to all the aspects that I mentioned, that is the nature, gravity, and so on and so forth. And this can be up to 250 crore rupees, which is equivalent of, in today's term, around 30 or 31 million US dollars. So with that, I think we have gone through the 12 different requirements. If you notice, there are no specific for sensitive data, as we discussed in the key terms. The 12 requirements are the grounds for processing personal data, where it's heavily reliant on consent, making contracts with data processors, ensuring adequate security, notifying on breaches, personal data retention, contact for concerns and complaints, rights and duties of data principals, role of the significant data fiduciary and the additional requirements like DPIA, rules about processing of personal data outside India, and also the exemptions which are allowed by law, and the Data Protection Board of India, which will be constituted, and finally the penalties. So with these 12, we've reasonably covered different key requirements, as I call it, in the Digital Personal Data Protection Bill. And if I use the terms which were not comprehensible, there's already a video on key definitions in Digital Personal Data Protection Act or Bill of India. So with that, I hope this was useful. Thank you so much for watching. And for those of you who are watching it for the first time, my name is Punit Bhatia, and I help companies and executives understand and manage privacy and AI risks. How do I do it? By defining and implementing strategies for compliance with privacy laws, AI laws, or even in terms of ethics, and then also by ensuring governance and training. Now, if you like this video, please share it with a friend, click subscribe button, make a comment. Let us know what kind of videos you would like to have. And if you've already done so, thank you so much. Goodbye for now, and keep protected.